In a Canadian case, there was a lease of a motor vehicle. And under the terms of the lease, the lessee was obliged to guarantee the residual value of the motor vehicle at the end of the lease. And that put option clause in the lease converted what was a simple lease into a conditional sales agreement. So it didn't matter that it was called a lease. The court said, in substance, this is a security interest because you're guaranteeing performance up to the point of the put option. So that's what the courts will do, and there's clear indications in the bill that they're entitled to do that. Not only will the bill cover what I'd call real security interests, which secure payment or performance of an obligation, the bill also applies to deemed security interests. And there are 4 different types of deemed security interests. Situations where there's an interest or right of a transferee of an account. An interest in a transfer of an account. Now, an account means a book debt or an account receivable. They don't call them that under the bill, they call them an account. So a factoring arrangement is a deemed security interest. Also, what's called a PPS lease is a deemed security interest. Now, in essence, a PPS lease is a lease of personal property for more than 1 year, or for an indefinite period, or, if it's a motor vehicle, for a period of more than 90 days. So we're talking about relatively long-term leases here that are deemed security interests. Another example of a deemed security interest is chattel paper. And chattel paper relates to a monetary obligation and the transfer of specific intellectual property or specific tangible personal property. A classic example of chattel paper is a hire purchase agreement or a reservation of title clause or a malpa clause. And the fourth and final type of deemed security interest is a commercial consignment. You're familiar with commercial consignments through floor plan arrangements. Now, what is it about these 4 different types of deemed security interests that they have in common? The thing they have in common is the potential for deception, because a third party is dealing with someone who appears to have ownership, but they don't have ownership. The ownership lies somewhere else with the reservation of title supplier, or the real lessor, or the consignor under a floor plan arrangement. So there's some element of possibility of deception there, and that's the thing that links them together. And that's one reason why they're brought within the regime. But they're also brought within the regime to stop restructuring of transactions to get around the regime. If you left these outside, people would restructure the transaction to escape the regime. You can't do that under this regime. So deemed security interests are included whether or not they secure payment or performance of an obligation. They're in anyway. If they secure performance of a payment or an obligation, then they are real security interests. Now, one of the fundamental concepts that we need to grasp in relation to the new regime is that it treats the debtor or grantor of the security interest as if he or she or it has some of the attributes of ownership. It treats them as if they're a kind of owner in a sense. And that's illustrated by Graeme and Portacom, the first New Zealand case under their regime. The facts were relatively simple. Portacom agreed to lease 5 transportable homes to a company called NDG. And these homes were to be supplied over a 4-year period. NDG wanted to obtain some further finance, so it approached its bank. And the bank lent NDG some extra money in return for a mortgage debenture, secured over the entire assets and undertaking of NDG in the usual manner. NDG defaulted under the mortgage debenture. Receivers were appointed, Graeme in particular. Graeme came to court and said, "Can I sell these transportable homes?" And the court said, "Of course you can. Do you want fries with that? Because you have a perfected security interest. Your bank registered the security interest and perfected the security interest. Portacom, on the other hand, the real owner, the lessor, did not register a security interest, and portacom dipped out. Now, to someone who studied their property law in the late 60s, that's an extraordinary result. The owner, the lessor of the property, the real owner of the property, misses out to a third party who's been dealing with their lessee. Whatever happened to nemo dat? Nemo dat non quanto bet, which I'm sure you talk about every night. You cannot give what you don't have. Well, what the court's saying here is that the lessee in Graeme and Portacom, NDG, had some of the attributes of ownership. They had enough of an interest to be able to transfer it to the bank by way of security. And that was enough to attract the regime. So some of our traditional concepts in property law are going to be challenged by this new regime. Thank you. Apart from coverage, one of the benefits of the regime is the register itself. This is an online notice board, fully electronic, backed up by contact centres, but it can be accessed with a web browser. There'll be a business to government channel, dedicated channel for access to this register. And I think in time everyone will start using electronic lodging and electronic searching. That's the experience in Canada. In fact, some provinces in Canada don't use paper at all. There isn't even the option of doing manual searches in a registry, manual lodging in a registry. It's all done online. And this register will record actual and prospective security interests. Now that's quite interesting. You can record a security interest on the register even if you haven't reached an agreement with the debtor or grantor yet. You reach it in advance. You can lodge it in advance. So it covers actual security interests and prospective security interests. There's a lot of case law on seriously misleading registrations. In this book I looked at probably over 800 Canadian cases and 25 New Zealand cases. There are over 300 Canadian cases mentioned in this book because I've culled them just to look at the relevant ones. A lot of those cases are on this very issue of seriously misleading registration statements or financing statements. For example, if you are required, as you are, to register a motor vehicle with a serial number, if you make one mistake in the numbers, in the serial number registration statement, that is ineffective. It's a seriously misleading registration. It will not perfect the security interest, and that security interest will be ineffective. But there are other ways in which you can render a financing statement ineffective. You might misspell the name of the debtor or grantor. And the current version of the bill is persisting with exact searches, not fuzzy searching, not wildcard searching, but exact searches. So you have to be very accurate in your financing statement and the filing statements that you put in. Thank you. Another benefit of the regime is supposedly comprehensive and clear rules about all these new matters: attachment, perfection, extinguishment, priority and enforcement. And we'll go through those in more detail in a moment. Those of you who are insolvency lawyers or commercial lawyers will be familiar with the concept of attachment. Attachment is the process whereby a floating charge becomes a fixed charge. It's the process of crystallisation. It perfects the equitable assignment by way of charge. That's what attachment means.